on the behalf of the people. And so it was left wide open, but the court made a decision that they cited the old colonial records, improved commentators, etc., and they cited that able-bodied men were to appear at muster bearing arms supplied by themselves of a kind in common use. And they further made a statement about the shotgun. It wasn't within judicial notice of them that it was any part of military equipment, or that its use could contribute to the common defense. They used cryptic language there, and they put a positive statement in a negative context, but it still reads exactly the same. If you're an able-bodied male and you possess arms of the kind in common use of the military, the arms are protected by the Second Amendment, and that goes right on down to any standard military equipment. There's just nothing prohibited. As a matter of fact, the Founding Fathers knew very well what arms were. I believe they were rockets fired off the British ships there at Yorktown, trying to save Cornwallis's army from Washington. And if you remember, I believe the first submarine was the Turtle, I believe it was. They were working on machine guns back in the 1700s, hand grenades, rockets, cannons, artillery, mortars, etc. So these gentlemen knew what arms were, and they knew how to write an amendment to protect it. But the court was asked to settle a controversy there, and the court settled it. Most people just don't have what it takes to read it and say, yes, there's no more controversy. Arms of the kind in common use, or arms that could contribute to the common defense, are protected by the Second Amendment. And to dismiss this case that it's a collective right and not an individual right, when the court allowed Leighton and Miller to stand before it and contest it, it settled that argument also. So it is an individual right to keep and bear arms. If people will study the Miller case, you'll find the court gave all we need to show that anyone in the state or federal government trying to do contrary is an infringer.
Now, you talk about the court saying it's an individual right. As you know, there's another case coming before the court, assuming they're going to hear it, the Parker case. And that's a decision of Washington, D.C., where the lower court said that the ownership of firearms is indeed a right and not a privilege. Have you been able to follow the Parker case at all?
No, I've read a summary on it, and it sounds like the court got it right. I mean, it is an individual right. You have to have armed people before you can extract the militia out of it. And so everyone that has good standing in this country, the citizens of this country, the people unquestionably have the right to keep and bear arms, whether they do it one at a time or they band together and build artillery or whatever they need. The right to exist and to preserve life is a higher right than anything that government has, and it's a mandatory upon a society to protect itself. That's what we instituted government for, but they've let down on quite a bit.
What would you say to people who would question if artillery would be considered arms?
Well,
people like that out there.
The Arkansas Constitution says volunteer companies of infantry, cavalry, or artillery may be formed with, I'm paraphrasing, but with such regulations as the legislator may pass, and that means good legislation. But artillery is so mundane in warfare that it's unquestionable. If you're going out with the intent to come back alive and protect your family, your home, your community, your state, or your country, it would be dereliction of duty to not consider artillery to whatever degree it might be. You know, we have thousands of miles of shoreland and inland rivers that a enemy could navigate, and to not have at least some artillery would be not very wise.
You know, before the 1968 Gun Control Act, before this concept of sporting purpose came into being, if you recall, you could buy cannons.
I believe it was a 20 millimeter.
Okay, 20 millimeter. But you could buy them through the mail.
Sure.
For about $350 plus shipping. And you could buy anti-tank rifles, which I think were also 20 millimeter. So the sporting purpose concept after 1968, in effect, has made it possible for the government to start disarming Americans so they cannot defend their country. Would you agree with me on that?
Well, sure. Anything that we, the people, decide, the only limitation of the right to keep and bear arms is just our willingness to do it and finance it. That's all. Whatever we perceive that we need to defend ourselves, it's within the scope of the right to keep and bear arms to do just that, keep them and bear them. One of the key words in the Second Amendment is the word bear, support, uphold, carry, but it also means produce or bring forth. To produce or bring forth your own arms is one of the parts of this, powerful parts that most people don't even read into it or don't even understand. We have every right to go out here, a group of men, and put together any artillery piece. We should be buying, released to us, used Army equipment, still with a lot of life to it, the artillery, and we should be at the military ranges practicing with it, where we would know and be able to train the youth on up the real necessity of being armed to prolong freedom, because this is a dangerous world. There's a lot of countries out there that don't particularly care for us. They like what they get from us, but they'll turn on us anytime they get a chance. And an armed nation is a very strong deterrent to that.
This is Talking to America. Our guest today is Hollis Wayne Fincher. My name is Aaron Zellman. I'm your host. And we're talking today about the lawsuit that Wayne is involved in, where apparently the government's decided the Second Amendment doesn't mean what it says. Is that a fair way to sum it up?
I believe that's the way they've got it. They're trying. They know what it says. The Second Amendment speaks for itself. It was written by some of the finest English scholars that ever walked the earth or ever will. It contains enough information to perform its function. It's the law of the land. It can be understood, and they know exactly what it says.
Well, what would you like gun owners to learn from the situation you're in? And what would you suggest gun owners do to bring back the Second Amendment to its full glory?
Well, until they first learn themselves and understand our Second Amendment to where they can't be pushed around, they can't be deceived of the meaning of it, you're just going to be a leaf blown in the wind till you fully understand the meaning of the Second Amendment, the scope of it, and the power of it. And it's not negotiable. It's the law of the land. All of the people in state and federal government swear to uphold the Constitution for the United States. And for them to pretend that they can't understand that, or the oath of office allows them to infringe it, is just absolutely deceptive and criminal.
Well, what would you suggest gun owners start doing, though, so that they don't become a victim as you have?
The whole purpose of the Second Amendment was for an armed population to have enough arms to effectively put together a militia. And if you don't do that, you might as well forget liberty. The militia is as American as anything else. It's as much a part of our Constitution as any other part of it. And the people need to form up the volunteer militias. They need to go to call your state capitol and get a copy of your Constitution, or get several of them and read them. Read the United States Constitution. But if not you, who? If not now, when? When will we be stronger? As Patrick Henry would have said. This militia is you. It's me. And I've been here. I'm standing up. I don't like the thought of going to prison, but there was a lot of good men died, good women,